Welcome to VNA Health Highlights, a program of the Visiting Nurse Association of Cape Cod. I'm Jean Sarnoski, and on today's program we're going to learn a little bit more about elder law and what it means to you. We're lucky enough to have with us today attorney Amy Kular. We had to get the name right. Thank you, Amy, for being here. I appreciate your time.
Well, thank you so much for having me, Jean.
It's a great topic. I mean, I know there's people out there with all kinds of questions in mind, but we're going to start with how long have you been doing this and what sparked your interest into something like
Well, that is a great question. Before I went to law school, I was employed as a corporate paralegal in Boston, and I realized that I did not want to have a job where I didn't get to interact with clients daily and feel like I was actually helping people. So I kind of knew I wanted to focus on estate planning when I went to law school. And then I was lucky enough to find a job here on Cape Cod working with Attorney Mello, who has been specializing in elder law for almost 20 years now.
Oh, really? Perfect.
Yes.
Yeah. Oh, good. So you've been on the Cape for?
For 5 years now.
5 years. That's good.
Yes.
You like it?
I love it.
Yep. But you were sort of semi-local anyway.
Yes, I grew up in Norwell High School, and then I went to Wellesley College, and then I graduated from Suffolk University Law School.
Excellent.
Yes.
So how long have you been doing this?
For estate planning, yes, 5 years.
5 years. Okay, very good. So when we started developing this program, you were kind enough to and it was a great way to do it because I think viewers are probably thinking the same thing as, give me 20 questions of what kind of people or what kind of questions people ask you. So that's sort of, we'll go down that path. So a lot of people probably have an attorney that they've used for other things, selling their house, divorce, kids problems, whatever, but not the same as an elder law specialist.
No. A lot of attorneys do probably have the capabilities of making a simple estate plan or a basic will, but what we find in the community on the Cape is that a lot of our elders and seniors have concerns that are a little bit outside of the scope of maybe someone who only does wills occasionally or basic wills.
Right. So when you said estate, there's, I'm sure, viewers that are even thinking, well, I don't have an estate.
It's
you know,
so
when you
funny.
have the image of an estate is not quite the same as your definition.
I used to think the same way.
Yeah.
I used to think, oh, I don't have a plantation or a manor or something. That's not anything. But any person who owns anything really has an estate. So it can be real property, which is real estate, your vehicle, your bank accounts, the stuff inside your house. That's all your estate.
Oh, okay.
It all has to be dealt with, unfortunately.
Yes. So the essential documents for an estate plan.
Yes. There are a few that I don't like people to leave my office without. And
good.
The two big ones while you're alive are the healthcare proxy and the durable power of attorney. Those documents are extremely important while you're alive.
Okay.
And again, you can either have a last will and testament, and to go with that, some people like to choose a trust that suits their needs. So that is a basic estate plan, I would say.
Okay, so we'll walk through those. So the power of attorney,
yes.
Was that the first one? Yeah.
That's a document where you or I would appoint a person, an agent, to act on our behalf in matters related to finance or real estate.
Okay. Is that usually the same person? I mean, is that somebody?
For a lot of married couples, it's usually your spouse.
The other guy?
It should be.
Okay. It should be.
If you can't name your spouse as your power of attorney, there's a lot of things you need to think about.
Yeah, bigger issues.
Absolutely.
Yes.
But it can also be a very trusted child or friend or sibling.
If there is no spouse, say
Exactly.
people are widow or widower.
Our single clients often choose a child or a sibling or a really close friend that they know is a financially sound person.
Okay.
So that's very important when you're it's literally, you can take that document and I could go, if you appointed me as your power of attorney, I could go and take out a mortgage on your house.
Really?
And you wouldn't need to be there.
Wow. Okay.
So definitely trustworthy.
Yes, it's a powerful tool.
Absolutely.
Yeah. So the next one was healthcare proxy?
The healthcare proxy is a document, again, it's in effect while you're alive, and you appoint an agent to make decisions on your behalf, anything related to medical decisions on your behalf. The only thing that's different about the power of attorney is how it goes into effect. A doctor has to certify in your medical records that you are no longer capable of making your own medical decisions before someone steps into your shoes. Wow. But the power of attorney, I could have you sign it today and go straight across the street to the bank.
So the doctor makes the determination that you are no longer capable of making your own health care decisions. Is that right?
And it's a very high standard because doctors don't want to take away someone's liberty in that
Yes.
manner. So
when would that happen? I suppose if somebody was in a coma or something like that.
that's a
and they
really good
haven't
example.
planned?
Yes.
Yeah.
So if unfortunately someone falls into an illness where they're not responsive anymore, then a doctor is definitely going to certify that we need the healthcare proxy making decisions. In our elder community, sometimes we see it if someone develops a diagnosis of Alzheimer's or dementia. Maybe they're less able to fully understand the medical decisions and make an informed decision. So then the doctor might also want the healthcare proxy to be activated at that time.
Does it tend to be the same population of people that you draw from the
It can
other
be and it
financial
can't be.
group?
So if, for example, if I have a client who has a child who's an accountant and a child who's a nurse, I would probably say,
Oh.
name the child who's an accountant your power of attorney and name the child who's a nurse as your healthcare proxy.
Okay.
But it can be the same person.
If it's your spouse is usually both, if things are
Yes.
going good that way?
If both spouses are sufficiently competent to make the decisions for themselves, then they're likely competent to make the decisions for their spouse.
Okay, very good.
Yes.
Now, people will have to be taking notes on all of this. Okay, a living will
So
is something else entirely.
And that's a document, number one, it's not legally binding in Massachusetts.
So the other two are?
Yes.
Okay.
Healthcare proxies and powers of attorney are legally binding. A
Okay.
living will usually is necessary or needed if the person making your healthcare decisions is not your spouse. It's more of a guide about how you would like to be treated should you become incapacitated or be in your last illness. And it will state that I do want, for example, tube feeding, or I do not want tube feeding. It gets more specific. It helps. I like it when it's not a spouse making a healthcare decision and we have children that maybe haven't been able to have that conversation with mom or dad.
Yeah.
You know, it's hard for kids to have that conversation.
Right, or if they're at a distance, especially in the population we have here, you might have kids that are in states far away and
Exactly.
you want something written down that guides them.
It helps give peace of mind. Maybe there's a child who's a little headstrong about decisions, but they're not the named healthcare proxy. It will help shield the healthcare proxy from criticism if it says, no, mother did not want to be left this way. You know, she left this document so I could make an easier decision.
Right.
So again, the doctor doesn't have to adhere to it. So it's a little bit different. Sometimes people get them confused with do not resuscitate orders,
Yes.
but they're not the same at all.
Okay, that's good. Good to say that.
Yes.
Yeah. So, do you find conflict at all in stressful situations at the end where
It can happen.
Yeah, but it says it right here.
Well, it can happen. So if someone has a do not resuscitate order, that is something that should always be respected and followed by the medical community, and they're going to adhere to that first and foremost. But
Okay.
if someone doesn't have that, then there can be conflict among families where maybe one child's been the child on the ground, we like to say.
Yes.
They're taking mom or dad to their doctor's appointments. They know what the deal is. And then if the kids are flying in or driving in and, wait, you can't take mom off the respirator, you know,
Until I
she's
get
going to wake
there,
up.
yeah.
And
yeah.
then it's kind of hard for people because it is a hard time for families.
Yeah.
It's definitely something that none of us are prepared for until we get to that point, I would say. So it's better to set things up in advance
Yes.
and speak with your family and have that hard discussion about these are my wishes. I'm appointing this child for this reason. But generally what we see is families come together and they all make the decision together. It's just there's only one
that's
person
great.
who can speak to the doctor legally.
Okay.
'Cause that's what doctors want, is just one person making
Too
the decision.
confusing otherwise, yeah. Yeah. So another good reason to get it done in advance is just to make things better when the time does come within your own
Exactly.
family.
Exactly. It makes things easier, and there is a smoother transition. And there's a relief for families when they call and they're saying, my mom's in the hospital, I can't find her healthcare proxy. And I can say, I can fax that right over to Cape Cod Hospital for
Oh,
you.
right.
That's no problem.
Excellent.
And it is a great relief for families.
Okay. So let's move into what is a trust.
Oh, sure. A trust is an entity that you or any person can create. They are the trustor or grantor, the creator of the trust, and you can use that entity to hold your assets. And it's kind of funny. Why would people do this? You might have heard.
Because didn't I just do that with my estate? Is that right?
It's kind of, you would retitle your assets in the name of a trust. And the main goal for people on a basic estate plan with a trust is to avoid probate. The probate process is something that happens to every person who dies with property. You have to go through the court system, and it takes a long time, and your family won't get access to your assets for 1 year from date of death.
No matter how organized you are?
Exactly.
Okay.
If you left everything with just a will, you would have to go through the probate process, which people find it a little invasive to deal with the court system sometimes when they're grieving a death,
Yeah.
but we might have real estate that we need to take charge of. So it will be more costly on the other end if you don't, with the probate process, if you choose no trust. A trust will make it so that your real estate can pass to your beneficiaries the day you die.
Oh.
As opposed to a will, under Massachusetts law, creditors have up to 1 year from the date of death to make a claim against an estate. So I would never advise any clients to distribute assets until 1 year has passed. So if you think about that, that's a long time to wait, especially
Right.
if someone is kind of, I don't want to say this, it's a little morbid, but counting on some finances to come to them.
Sure, yeah.
Or you structured something that you wanted them to have the money immediately. It won't be as quick without a trust.
Without a trust.
And it's also private. So wills are public record once they're filed at probate court.
Really?
Yes. We could go down, and I'm sure he didn't have one, but we could go look at Ted Kennedy's will and see how he did his
Distributed
estate.
everything? Sure, yeah.
If we wanted to, but I'm sure he probably had a trust.
So a trust protects
Yeah.
and keeps it more private.
It does. Those are the
Okay.
benefits, and while you're alive, you can make any changes you want to your trust document and the beneficiaries and the assets up until the day you die, really. You can
Okay.
add things to it. And it also lends, for people with more complicated situations, it adds a level that we can take it to protect certain special needs that people might have in their families.
Okay.
So,
What about the 5-year look back?
oh yeah.
That's
Well, that's for Medicaid, and that relates to nursing homes. In our office, and as elder law attorneys, something we also do as part of our estate plan is get people's affairs in orders in the event that they ever have to qualify for long-term care insurance from Medicaid, and that program is run by Mass Health in the Commonwealth of Massachusetts.
Okay.
So any transfer you make is a disqualifying transfer. So a transfer of assets, you give your car away to your son, give your house away to your daughter. It's a disqualifying transfer for 5 years. If you did this when you were 75 and
At age 79, you get
needed to go in the
interim-
nursing home, unpredictable nature of
Yeah.
illnesses,
They can still tap into that.
we'd have to reverse those conveyances.
Okay.
So a good age to start this kind of planning, because I don't have a crystal ball, is probably around 70. And we have a lot of strategies we use to protect assets and make it through the 5-year penalty period so that those assets will be there for your heirs after that 5 years.
So what sort of strategies do you have?
Sure. We have a couple of things we like to do. While people are alive, you can make what's called an irrevocable trust. And that is a trust where you would appoint that trustworthy child as a trustee.
Okay.
And basically the trustee has all the control over the assets that you put in your trust. And we have language in our trust that do allow you to qualify for long-term care. Hopefully your children aren't going to sell the house out from under you after you make it through the 5-year penalty
Right.
period. That's why it's called a trust.
Yes. Good point.
We also have something we do that we convey property to children and retain a life estate in the deed for our client so that they're the life tenant of a property. But on the day they die, their children become the 100% owners. And if you make it through the 5-year penalty period with that deed, and that's how you did your property planning, then you would qualify for long-term care, and your interest in your property would not be a countable asset to Mass Health. This is very complex
It
areas.
is very complex. Yeah, that's why they need to come talk to you.
I would
That's right.
absolutely
I'm trying to think of a real life example. So you'd say, so my parents have a
Sure.
house.
Yeah. So if you came to me and said, my mom and dad have a house here in Dennis and we'd really like to save it from nursing home care, they're not looking
Okay.
too great.
Yes.
And I would say, well, the first question I always ask is, do you have long-term care insurance? Because that definitely makes it so that we have more options available to us if people do. Because we might make it to 4.5 years on the 5-year penalty period and say, you know what, the long-term care will bump us to the end. But if you don't, if your parents don't have long-term care or you didn't get long-term care, it's okay. We can still talk to you about what your goals and wishes are for your assets and probably come up with a suitable estate plan, not just for married couples, but also single people. These are all available to them.
Okay.
So we do something with spouses that's called a testamentary trust. And a married couple would say, I leave everything to a trust for the benefit of my spouse. There's language in that trust that says that none of those assets I left to them can be used for nursing home care.
It can be that simple?
It can be that simple, but for that to work, a testamentary trust is actually a trust inside a will. So someone has to pass away for that to work. So it's not maybe the catch-all at the end.
Yes, yeah.
So that's kind of like, sometimes we can do that for people, but it might not be ideal for everyone.
Right.
You might want to know and be able to be at peace with the fact that you made it through the 5-year penalty period and your assets are definitely secure.
Okay. It gets a little complicated.
It is a very complicated area of law. That's why you should come to an elder law attorney.
That's right. So when you have someone say, well, then I'll just sell my house to my daughter for $1 now and live in it, and we have this deal, and she's okay and I'm okay.
I've seen scenarios where this has actually worked out in real life, but it's not probably the best way to go about it if you want to make sure that it's going to be secure against nursing home expenses. In our deeds, we like to put language in it. What if your daughter runs into creditor issues and she doesn't want you can't live in the house anymore because the creditors have attached your house? So you might have said, oh, we had an agreement that I could live here for the rest of my life, but if you just went down to the registry of deeds and did that deed yourself, you might not have put that language in.
Yes.
So there's a lot of people understand that they need to do something, but definitely in our practice, because we specialize in this area, we know the little things we need to put in to make sure that we're going to make it.
Right.
And it's going to
actually hold up.
Exactly.
Yeah. Is it the same with other pieces of the estate?
Sure.
Anything, cars, money,
so
other
in
property?
the Commonwealth of Massachusetts, actually, a trust can't own a vehicle.
Really?
That's one of the few things that
There
cannot
you
be.
go.
That's one of the things that always gets probated. So I always tell my clients that are doing this kind of planning, don't go out and buy that last car and have it be a Ferrari or something, because anything over $25,000 in value is subject to a formal probate in Massachusetts, and that's expensive, time-consuming,
Definitely,
and
yeah.
costly. So it's not really worth it.
Yeah.
So I always tell them to kind of, the last car should not be your best car.
Right. Oh, so people that may have the thoughts of, I'm not worried about being in a nursing home because of I'm a vet, or I'm going to move to my son's house, or how do you guide them?
Definitely, we have a lot of veterans who are part of our practice and in our client base, and I don't have very many people that have ever ended up at a VA hospital for long-term care.
Is that right?
You might technically be entitled to long-term care from the VA, but unfortunately, number one, there's no VA long-term care hospital facility on Cape Cod.
Right.
So that is a challenge. I believe the closest one is Brockton, and then there's also one in the greater New Bedford or Fall River area. And so think about your spouse having to drive that far to come see you in the nursing home. That's not a great thing. And then the other thing to think about is that unless you were 100% disabled because of your military service, you're not at the top of the priority list. So you might be on the waiting list, but you might never get into that long-term care. So generally, I advise my veterans it's better to plan with Massachusetts and Medicaid rules in mind as opposed to VA rules, because those tend to be very a little bit different from Medicaid law, and also the chances that you're going to be able to avail yourself of their services are pretty low if your home base is down here.
Right. Just the availability of the services is going to be limited.
That's true. So we don't like people to say, oh, the VA is going to take care of me. They might eventually take care of you, but probably not on the Cape.
Yes.
So that's a big challenge for some people.
Yeah, if you're used to this area, or your family are here, or something nearby. So long-term care insurance, is that something that you recommend to clients?
I absolutely recommend it.
They're all so different.
It's really difficult for some people to maintain it because the premiums are costly. And when you're in retirement and on a fixed income, it might become a financial hardship. So currently, the average that we're seeing for nursing home care per day is between $350 to $375 per day. So if you can get a policy that will cover you that much and it's not going to be a financial hardship for you in retirement, I would say go for it because nursing homes are expensive. That comes out to around $12,000 a month. But most of us aren't so lucky to be able to afford those premiums. But if your employer offers it, or if you're lucky enough to have been a government or town employee, sometimes municipalities offer those kind of policies. Those are some of the best ones I've seen. But definitely you need to weigh what your costs and needs are going to be as you age, and have a really good planning meeting, not only with an attorney, but also with a financial advisor who you trust,
right,
that can help advise you as to the best policy that you can afford. I recommend it, but it's not really for everybody.
Right.
Because they can't afford it.
They can't. And sometimes it's cheaper if one gets on board earlier in life, but that's not when you're thinking about it.
No, definitely it's not something I'm thinking about right now.
Right.
So I can understand why people might not, but maybe if you can still think about it in your early 50s and it's still an option for you and you don't have any existing diagnoses or family histories, it might be something to look into at this time.
Yep. So you probably have clients that are concerned about maybe children that are disabled and what's going to happen to them after I die. And
oh, absolutely. That's a huge concern for actually many of our clients.
Really?
They might have a child that is currently either on SSI or SSDI or is just simply unable to work and really needs their mass health for whatever reason. And absolutely, if they inherit 1/3 of your even $300,000 estate, to use a round number, they will be bumped off of their programs.
Wow.
Unless you've created either a trust dedicated to them to receive their share of your estate, or included language in your existing estate plan documents inside your trust for their share saying that you do not want them to lose any of the benefits they're entitled to. So it might be, for example, let's say your child has a mental illness and they inherit a lot of money from you. That money will be gone immediately.
Right.
You know, we can't say, and they could lose their housing. They could lose their health insurance.
So you're saying, just so I understand, that if they are given a lump sum after your passing without some sort of guidance of management of it,
Correct.
That's when it could be problematic.
Absolutely. People intend to do things like just treat all the kids equally, and
Right.
I absolutely understand that. We should do that, and I recommend most people that's what you do. But if we treat everyone equally without putting in some language to protect the child that does receive
That may
benefits,
have- yep.
then they will lose their benefits and kind of imagine the chaos of your child without benefits is what I like to say to
Yeah.
people, unfortunately. That's what can happen even though you meant so well. Or if you die without a will, then they're entitled legally to 1/3 or 1/2 or however many children you have of your estate.
Right.
And if you pass away, it's called passing away intestate, then we have to follow the statutory laws that say they're entitled to that share. And there's nothing we can do to stop it.
Is Massachusetts, is it a state law or do you have federal guidelines as well?
So probate law and estate planning laws are generally state laws.
State laws, okay.
Yes. Federal law is Medicaid law. It's just how we choose to apply it in the Commonwealth.
Okay. Now, if someone has not that many assets and or they hear, at the beginning of the show we talk about the estate and they think, yeah, but I got nothing.
Right.
Does one still consider
At least
having a plan?
I would consider a
Other
plan.
than just a will?
Well, those living documents that I touched on, the healthcare proxy and
Yeah.
the power of attorney. If you don't have a healthcare proxy or a power of attorney, and let's say through either a sudden medical event or a gradual decline into an illness that affects your mental faculties, your children or your friends, your husband, everyone would have to get a court order to be able to make those decisions for you related to finance or healthcare. And that's extremely costly and time-consuming and stressful. And then you also have then a government entity involved in your private life. So a lot of people
And
like
I'm sure nobody likes the sound of that.
I don't think anyone really wants to get involved in the court system,
Right.
Unless they have to.
Yeah.
And even though the probate court is the nicest of all the courts, probably because there's no criminal matters there.
Yes.
It's still not nice to have someone
through
telling
it.
you what to do.
Yeah.
So make your own decisions.
That's good.
Yeah.
Plan ahead. So what about the people that have children that are yours, mine, and ours?
Oh yeah, blended families.
Yeah.
That's a
Well,
big.
I want my kids to get my stuff, and your kids can get your stuff. And
Sure, we see a lot of couples that maybe have remarried or married later in life, and generally what I like to do is take stock of what everyone brought to the marriage, how commingled their assets are at this time, and how long they've been married. So if husband has more children than wife, and then they have a mutual child, we really probably at that time would suggest maybe equally sharing everything. But if they were married under 10 years, everything is separate, all the bank accounts, all the the titles to the real estate, the cars, everything is
right.
separate still,
Yep.
then you probably want to make your own plan and talk about it in front of each other though, before, so there's no surprises. But we can accommodate any family dynamic in our office.
You've seen it all.
Oh, we've seen it all.
That's good. So, believe it or not, we have less than 2 minutes.
Ooh, that went fast.
It does, doesn't it? So I'm wondering, I have a couple questions, but I just want to be sure, is there something that we haven't talked about that you think is valuable for people to know?
Really, the biggest things that people want to know are about the 5-year look back. So that is a very complicated thing to talk about just between us without getting into specifics. And so I would advise anyone that wants more information on that to definitely, if they'd like to contact my office for more information, we'd absolutely be happy to consult with you. It's never too late to make planning. Certain scenarios are more difficult to plan for, but we have the capability in our office. There's 5 attorneys there, all specializing in elder law, that we have a wide breadth of knowledge and experience in these matters. So I feel confident that we could help almost any viewer today.
That's good. It's 20 years it has been that your agency or
Attorney
company?
Mello, I believe, started practicing in 1996 in Mashpee, and yeah, we're approaching 20 years in practice.
So that's pretty, I would say, expertise in the elder law estate planning.
We added up the combined years. I believe it's over 65 years of experience in our office.
Very good.
So we're a good place to start.
Trusted for the trust.
I think so,
yes. Very good. Well, thanks, Avi, for being here today and sharing all that great information.
Oh, it's been my pleasure. Thank you so much for having me.
You're welcome. It's good that it's going to be recorded. You can go by, we'll go back and review this again and take more notes.
Yes.
Right. Yes. Very good. All righty. Then I'm Jean Sarnowski, wishing you good health and good health care.